Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. I'm Pinky Webb. Today on the program, Isko Moreno's political party asks the Supreme Court to clarify the estate tax of the heirs of the late dictator Ferdinand Marcos. A former official of the agency tasked to recover the Marcoses' ill-gotten wealth says the Bureau of Internal Revenue should file a criminal case against the family. But the Marcos camp insists the issue is being used for politics. Former Presidential Commission on Good Government Commissioner Ruben Carranza joins us live. Manila Mayor Isko Moreno's political party, Acción Democrático, asks the Supreme Court for a certificate of finality on the Marcos family's unsettled estate tax that has ballooned to 203 billion pesos. The party has asked for the document to disprove the claims of Bongbong Marcos' group that the family's estate tax case is still pending in court. Marcos' spokesperson had accused rivals of using the issue for political gain. Let's go straight to the source of the story. We have former Presidential Commission on Good Government Commissioner Ruben Carranza. Commissioner, welcome to the source. It's good to meet you. I think you might have been on mute, sir. I did not hear you.
Sorry, thank you for having me.
There you go.
Sorry,
I can hear you now. Okay, first let's clarify this, Commissioner, if you will. Ito pong pinag-uusapan ho kasi lumaki na itong estate tax case, liability supposedly of the Marcoses. Number one, is this still under litigation or is it final and executory?
It's final and executory. It was final and executory in 1997, and it hasn't changed. That's what final and executory means. And I've noticed that the lawyer of Marcos Jr. Is deliberately obfuscating the circumstances of this case by claiming that it's not yet final, or by claiming that there is some pending litigation between the Marcoses and the PCGG that affects this tax liability. So that's all untrue, and there's no excuse for the Marcos family not to pay the taxes that are due.
So if it's final and executory since 1997, does that necessarily mean that since 1997, these dues should have been collected?
Yes, and to those who will then say, why weren't they collected 1998 and onwards? They were being collected 1998 and onwards. As a matter of fact, the reason that the case reached the Supreme Court was because the Marcoses challenged the collection, but the collection went ahead. So 11 parcels of land in Leyte were levied upon. That's what it's called when the Bureau of Internal Revenue seeks to sell property so that the tax liability of a taxpayer is paid. Even the Marcos house in San Juan was levied upon. And I'm not aware whether that's already been sold, but as a matter of fact, it can be sold by the Bureau of Internal Revenue to pay for this huge tax obligation of the Marcos family.
But when you said, Commissioner, that this was still questioned by the Marcos family, was this questioned before 1997, hence the final and executory state happened in 1997, or was it questioned after 1997?
It was questioned before 1997. It then became final.
Okay.
And after that, the levies went ahead.
Okay. So I want to understand this better and help our viewers understand this as well. I did read about that 11 properties supposedly in Tacloban were levied. Ano ba ibig sabihin nun sa Tagalog?
Ibig sabihin, ang BIR binigyan ng notisya yung pamilya ni Marcos na ibebenta ng BIR itong mga ari-arian nila para mabayaran yung buwis na ayaw nilang bayaran. Malinaw kasi na yung 11 parcels of land, no, yung mga lupa na nasa Tacloban, nasa pangalan ni Ferdinand Marcos at nung estado niya, kaya pwedeng bawiin ng BIR at ibenta.
At nabawi ho ba itong 11 parcels of land?
Sa pagkakaalam ko na benta at isinama na doon sa kinaltas na doon sa dapat bayaran ng mga Marcos.
So, in
Pero ang
spite...
laki ng utang nila,
Ayun na nga
203
po.
billion.
So, kung 203 billion, kinaltas pa ho itong 11 parcels of land sa Tacloban.
Tama.
Nakaltas pa to. And it's still 203 billion pesos.
It's probably lesser than 203 billion pesos now, but the fact is that because they haven't been paying, that penalty and the interest on the amount due is still tolling. Ibig sabihin, meron pa ring penalty, meron pa ring interest even as we speak right now.
And let's go back to that ruling in 1997. Because when you look into and research on this, there are two Supreme Court rulings that are normally identified. There's a 1997 ruling and a 2003 ruling, if I'm not mistaken. It's in 1997, Commissioner, na sinabi ng Supreme Court na merong 23 billion pesos na estate tax na dapat bayaran. Am I correct?
That's correct. And ibig sabihin, nag-compute ang BIR kung magkano yung estimate nila sa estado, no, value ng estate ng mga Marcos, at binase nila yan dun sa kiniklaim naman ng mga Marcos na amin yan, yung lupang yan sa akin, yung mga pondong yan sa akin. So it's on the basis of their own claims that they were assessed 23 billion tax originally.
And further on, this 23 billion to this date has actually reached 203 billion pesos. But I'm going to set that aside for a bit. There's another ruling in 2003, and I believe this is where the Supreme Court had looked into the legal, lawful income of the Marcoses, Ferdinand Marcos Sr. and former First Lady Imelda Marcos, to which the Supreme Court had said that kung pinagsama-sama yung kanilang kinita, I believe since naging Pangulo si Ferdinand Marcos Sr., ang kalalabasan po nito ay about 300,000 US dollars. And anything, sorry sir, and anything over and above that was deemed ill-gotten.
That's correct. And malinaw ang sabi ng Supreme Court. No? So dalawang punto ang kailangan ulitin. 304,000 lang ang legal income ng mag-asawa Imelda at si Ferdinand Marcos Sr. Anything above that is ill-gotten. Now, ang sinabi ng Supreme Court na yung Swiss accounts, na yun yung at the center of that 2003 decision, kasama doon sa ill-gotten wealth ng mga Marcos. Now, importanteng sabihin na hindi ibig sabihin na ang ill-gotten ay nakaw na yaman. No? Hindi ito ill-gotten na parang nauntog lang si Marcos, nakakita siya, kinuha niya yung pera. This was stolen, and this was stolen from the Republic of the Philippines. Nandun mismo yan sa Supreme Court decision. Sabi na this money was stolen by the Marcos spouses from the Republic of the Philippines. So malinaw na nakaw na yaman yung nabawi namin.
So there is nothing
2003.
wrong with saying na ninakaw itong perang ito, because that's exactly what the Supreme Court said in its 2003
Absolutely.
ruling.
And no one will be sued for libel if they say magnanakaw ang mga Marcos, because sabi ng Supreme Court, magnanakaw ang mga Marcos.
Okay. Didn't you have a problem with that in the past? Was that you?
Yes. Si Imelda Marcos, yung decision na yan ng Supreme Court, July 2003, lumabas yan. Nasa PCGG ako. 3 months, 4 months later, she sued me for libel dahil sabi ko, si Marcos, yung husband niya, ay magnanakaw at diktador. At dinimanda niya ako ng libel. Nag-file siya ng complaint sa fiscal. Nag-submit naman ako ng counter affidavit. Sabi ko, handa akong patunayan at totoo yung sinabi ko. Siguro natakot sa katotohanan si Imelda Marcos, hindi niya tinuloy yung kaso, na-archive yung kaso. Ibig sabihin, hindi niya handang ipagtanggol yung sinasabi niyang hindi naman magnanakaw si Marcos, at saka siya na rin.
But didn't you also edit that particular statement you made na tinawag niyo po siyang magnanakaw at diktador?
Sabi ko nagkamali ako na tawagin siyang na si Ferdinand Marcos Sr. ay magnanakaw at diktador, dahil dapat ang sinabi ko ay si Ferdinand Marcos Sr. ay patay na na magnanakaw at diktador.
So wala na po pala yung libel case that was filed, that was not pursued. So here's the thing, Commissioner, if this was final and executory in 1997, of course this is something I do need to ask Attorney Vic Rodriguez as well, because he was saying that it's still under litigation. There's two things. It's supposed to be under litigation, and was there really a verbal agreement? First, you're already saying it's final and executory. Here's my next question. Is a certificate of finality coming from the Supreme Court necessary? Why? Because Acción Democrático wants this.
It's not necessary, and to be fair to them, to their credit, they did correctly write a letter to the Bureau of Internal Revenue, to the PCGG, and I saw the response of the PCGG. They even referred to me because I was in a meeting with the BIR just before the July 2003 decision of the Supreme Court came out. Mm-hmm. And as I said, to be fair to the party that requested this was the correct thing to do. But it's really unnecessary at this point to ask the Supreme Court to say anything. It's right there. Even Marcos Jr.'s lawyer should know that. So he's obviously just making it up when he says that this case is pending, or when he says that there is a case pending between the Marcoses and the PCGG that affects this case. What's important to remember is that these are two decisions separately decided by the Supreme Court, one in 1997 that says the $203 billion now, pesos now tax assessment is final and executory, and there's a separate 2003 decision that says this is ill-gotten wealth.
So before we go on a break now, just jumping off on that point you were saying, kung 1997 pa ito, I don't think I got your answer right earlier. Na final and executory na to, it's already 2000, it's 2022. Mm-hmm. Bakit hindi pa nakukuha itong perang ito if it's final and executory? Does that mean that everyone else, with the BIR, maybe even with the PCGG from 1997 onwards, did not do their job?
Hindi naman siguro, because that's the reason why some property was collected. I think the Marcoses were also hiding property from the BIR, the same way that they were hiding property from the PCGG. Tinatago nila eh. They had 20 years in power, 20 years to hide their property, and only the property that is obviously you cannot hide. You cannot hide the San Juan house. You cannot hide the land in Leyte, but you can hide bank accounts, and you can hide other types of property from the BIR as well as from the PCGG, and that's what they've been doing.
We will be taking a short break. This is The Source on CNN Philippines. Please stay tuned. You're watching The Source on CNN Philippines. Our guest today, former PCGG Commissioner Ruben Carranza. Now let's talk about any possible verbal or written agreement. I spoke to Chairman Andy Bautista a couple of days ago, and he was saying that during his time as PCGG chair, which was from the years 2010 to 2015, if I'm not mistaken, sabi po niya, nagkaroon ng meeting in 2011. Him, the Marcos siblings, but it wasn't just really about the estate tax, but the assets in general. He met with them, and at some point, sinabi po ni Chair Andy na siguro nakikiramdam sila what the Aquino administration, if they would welcome such a possible negotiation agreement. But here's the problem, Commissioner. There was never a follow-up. Hindi po nagkaroon ng second meeting thereafter. First is, during your time, which was before Chair Andy, you were commissioner from 2001 to 2004. Were there any talks or any meetings or any agreements of such sorts?
Before we came in, there was already a Supreme Court ruling that striking down a compromise agreement signed between the Marcoses and previous PCGG officials. I won't go into the details of why it was struck down, but it was clear that there are parameters to any discussions with the Marcoses. Now, they did send their American lawyer to the PCGG, and he asked for a meeting with Chairperson Heidi Yorok at that time. Mm-hmm. They had a discussion, and it was made clear to them that any discussions of any proposal to settle coming from them will have to require a disclosure of the assets that they were still hiding. So as I was telling you earlier, they have been able to hide a lot of assets still over the 20 years they were in power and even after that. So that was important to us, that any discussions of any kind of settlement with the Marcos family requires a disclosure of where their assets are.
And did it happen?
It didn't happen. They refused to disclose. And that's why the case against them proceeded. And that's how we got to the 2003 decision declaring their Swiss bank accounts as ill-gotten wealth.
Again, just for context, Commissioner Carranza was commissioner of the PCGG from 2001 to 2004. The ruling was in 2003, so sa gitna po yun. So fast forward to Chairman Andy Bautista, sinabi nga niya, siguro this is another attempt to look into what could possibly happen. I guess I wanted to ask you how it really works around situations like this. Why meet with the PCGG? This is, of course, the Marcos siblings, meet with Chairman Andy Bautista, have it open-ended, and not really have a follow-up. What could be the possible implication, or what could this actually mean?
Well, I'll have to be very frank with you here. In the Philippines, elite circles, those in power, coming from the elite, often think that they can just negotiate their way out of their legal obligations, as well as the human rights violations and corruption that they committed. And that, to me, personally, is something I would not take part in. The Marcoses have committed crimes. They have committed corruption. They've committed human rights violations. And the fact that the PCGG, the Republic of the Philippines, won a decisive victory in 2003 should have ended any kind of discussions with the Marcoses over whether they would settle or not settle. The important thing is to enforce the judgment against them.
You really don't think talks were even necessary after that 2003 ruling?
Because what's the point of litigating and winning if you're then going to compromise on the victory you already had?
Maybe because it posed such a challenge, as you mentioned a while ago, that, as you said, properties were very hard to find.
Well, for the BIR, and I can imagine why, because there are different aspects to taxation from recovering ill-gotten wealth. But for the PCGG, after the 2003 ruling, and I think this has to be emphasized, that 2003 ruling became the basis of a 2012 ruling involving jewelry that was confiscated from Imelda Marcos. The confiscation she challenged, and using the 2003 ruling, the Supreme Court said the jewelry that was taken from Imelda Marcos from Hawaii, from a certain Romeliotes, jewelry smuggler, and jewelry she left behind in Malacanang, all of those are ill-gotten wealth. So 2012. 2014, another decision against the Marcoses came out of the Supreme Court, again based on the 2003 ruling. This 2014 decision involved an account here in New York called Arelma, which is now about $40 million. And again, the Supreme Court used the 2003 ruling to say that account, that $40 million right now in New York, it's ill-gotten wealth. So, ibig sabihin, ginamit na yung 2003 ruling, sunod-sunod na yan. Even today, if the PCGG finds assets that might have been hidden by the Marcos family anywhere in the world, the 2003 decision will apply to that.
Will stand, which is, again,
Yes.
as we go back, that their lawful income was $304,000 US. And if we were to multiply that by 50 right now, I'm not sure if this is the right number, sir, but would that be 15 million pesos?
It's yes, that's about the amount. The Marcoses did not file their income tax returns regularly. The Marcoses did not file their statement of assets regularly, and apparently that refusal to file tax returns and refusal to file a statement of liabilities is hereditary, because now Marcos Jr. is doing exactly the same thing, and that was their undoing. So no one is above the law. Not even if you were a dictator for 20 years, and especially not if you're just the son of that dictator who has nothing to show for everything that their family stole. He never finished his education. He has not accomplished anything except benefit from ill-gotten wealth.
But 15 million pesos, sir, lawful income, parang ang ibig ho sabihin nun, ang legal na pag-aari o pera, kung tama po ito sa 2003 ruling ng mag-asawang Marcos, ay 15 million pesos. Over and above that,
Right, because
yeah.
right, because they had every opportunity to show that they had other money, that they had other income, that they had legal income, and they didn't. They were given every opportunity to do that. Now, let me also make this clear. There are still assets out there that have not been found by the PCGG, that may still be recovered by the PCGG, and the 2003 decision, like I said earlier, will apply to those assets. Now, Marcos Jr. is the co-administrator of the estate of his father, together with his mother. If he has been hiding these assets, and in fact, this should be a separate ground for a criminal case against him for money laundering.
We need to
have
talk
an
about
anti-money
that.
laundering law right now in the Philippines. Yes.
That's what we need to talk about, but we need to take a very short break. This is The Source on CNN Philippines. Please stay tuned. You're watching The Source on CNN Philippines. Our guest today, former PCGG Commissioner Ruben Carranza. Commissioner, I still have a lot of questions. First this, ito ho bang estate tax na 203 billion pesos, ngayon is this really just between the BIR and the Marcos family? I ask that because sino ho ba talaga ang pwede lang kumolekta nito, be aggressive about it, and get the money? Is it just the BIR?
Well, under the Internal Revenue Code of the Philippines, which is the tax law that applies in this case, the BIR is the agency that collects, and the BIR is also the agency that can decide to file a criminal case for willful refusal to pay taxes. And obviously, years and years of refusal to pay is willful, and the BIR should already have filed a criminal case against the Marcos family.
Do you think they're doing enough, sir, the BIR?
I think that the BIR prioritizes, and I'm not saying this is correct or there's something better than doing this, but they prioritize tax collection over prosecution. But in this case, no one else in the entire country, in the entire history of the Philippines, has owed 203 billion pesos just for estate taxes. So that should require extraordinary measures from the BIR. In the same way, the PCGG carried out extraordinary measures to go after them.
But if we were to believe your argument, you said this might not be true. This is not gospel truth, that they are more looking into tax collection than prosecution. Then let me rephrase my question. Are they doing enough to collect the 203 billion pesos?
Well, my tax law background is not as extensive as my ill-gotten asset recovery background. But let me just say this. The BIR has several weapons in its arsenal to force the Marcoses to pay their taxes.
What are they?
One of these tools that they can use actually is clear in the Internal Revenue Code. When estate taxes are owed, the BIR has the power to go around the bank secrecy law. In other words, the BIR can actually ask banks in the Philippines for details about funds belonging to the Marcos estate administered by Marcos Jr. and Imelda Marcos, because it's an exception to the bank secrecy law. It's in the tax code of the Philippines. The BIR can ask banks because that's always one thing that perhaps journalists like you can ask the Marcos family. Where do they have bank accounts in the Philippines, and how much money do they have in these bank accounts?
And then they would probably say, why would I reveal such?
They will say bank secrecy, but for estate tax purposes, that's what I'm saying, the BIR can force banks to give them information.
I see, because of the bank provisions in the tax law over the bank secrecy law. Is that what you're saying, sir?
That's correct. Yes.
I see. You mentioned something before we went on a break that apart from that, there's a number of things the BIR can do. You said that a case can be filed against Bongbong Marcos, sir, for money laundering? Did you say that?
Right.
Okay.
Because
Could you expound?
in anti-money laundering legislation in general, including anti-money laundering legislation in the Philippines, which, if I'm not mistaken, was only enacted sometime in 2002, if I'm not mistaken, the filing of an anti-money laundering complaint must be based on what's called a predicate offense. You know, an offense in which you acquired assets that are ill-gotten that you then try to launder. No? Lalaban mo yan para maging malinis at maitago mo yung marumi niyang pinanggalingan. The predicate offense in this case is corruption. The predicate offense in this case is hoarding and hiding ill-gotten wealth, which is already a finding that's filed under the executory as from 2003. So any attempt by Marcos Jr. to hide assets that were acquired by his father and constitute ill-gotten wealth, because beyond $304,000 US, that's money laundering. The Anti-Money Laundering Council of the Philippines can actually act on its own, motu proprio, or complainants can file complaints before the Anti-Money Laundering Council to investigate Marcos Jr. for money laundering.
But you know, it's so easy, sir, to say that what property? What are you talking about? I'm not hiding anything.
That's what he will say. That's why, to me, there are several things that can be done. One, by the BIR to go around bank secrecy and force the Marcoses, force banks in which they have deposited their money to disclose what this money is. But on the other hand, even the PCGG right now, as they are, you know, the Duterte appointees in the PCGG can enforce the 2003 decision against the Marcoses. They, as a matter of fact, the PCGG under Andy Bautista did, in fact, raid Imelda Marcos's apartment in Makati to get paintings that she prominently displays whenever she's interviewed by
The
producers.
kingmaker.
But then she hides when the PCGG comes over. So they
Okay.
can obtain a warrant of arrest, a search warrant, I mean, and confiscate those paintings, even as we
I
speak.
saw that at the Kingmaker. One last question, sir. You said that the real estate taxes were final and executory in 1997. Is there such thing as a prescriptive period by which all this goes to naught? Wala na po ito dahil it's been decades after at wala pong naging resolution dito. May prescriptive period ho ba?
In general, yes. Decisions, the enforcement of decisions prescribed within a certain period. Here, I'm not sure if it's 10 years, but if the BIR, for example, does not continue to file a notice against the Marcoses to collect the estate tax within every 5 years, if I'm not mistaken, then there is possibility of prescription. That's why it's important to already keep doing this every year so that it never prescribes. And as I understand
see.
it, the BIR...
So pwede mo pong ulit-ulitin para po hindi mag-expire yung prescriptive period? Is that what you mean?
Right, because that's what you have to do as the Bureau of Internal Revenue.
So then,
Keep
because,
collecting.
sorry sir, because we know that there was a demand letter, the BIR said back in December 2021, it adds another 5 years if it is 5 years of the prescriptive period. All right, we've run out of time. Former PCGG Commissioner Ruben Carranza, sir, thank you so much for your time and good evening there in New York.
Maraming salamat din.
Thank you. And CNN Philippines has been reaching out to the Marcos camp for an interview on this matter, but they have yet to respond to our request. Thank you for joining us here on The Source. I'm Pinky Webb. You're watching CNN Philippines.